what she has filed a case against him for mental torture. He is being I
Grounded. Yes.
Now he has come to know about all this fact and why she is in urgency to get divorced because she has already taken it, this thing 6 months, within 6 months she got disposal. This was point in before him, after filing the appeal. Now he wants to incorporate all this point in his appeal so that if at all it is order is granted also, at least this one should be educated before the lower is required. And he will not get any further chance to incorporate all these things before the court. Because allegation is upon him also. It is not the allegation, but on the basis of mental cruelty, no other thing. And lower court has also come to know that because these are all the points which a husband should have to know. No one knows spouse will say all these things before the court.
These are the factual aspect decided by, will be decided by.
That is page 47, 48.
Yes.
And I should page 2.
Yes.
Sure, page number 49.
Yeah. What you want to show? Basically, consider all the totality have not referred to allow the application for the administration. The amendments are not necessary for the disposal of this case. Okay. Where is your petition?
Page 40. Absolutely a vague petition, madam.
Let me go through petition.
Page 40 is the operative portion.
Which Chandan Bisa? Yes, sir.
Yes, my lord. Kindly come to page 56, my lord, first.
56.
My lord.
Yeah.
Sorry, 55, my lord. Order number 9.
Yes.
Today, the case is fixed for appearance of both parties and evidence. Respondent respondent is represented by his learned lawyer. Petitioner is present along with learned lawyer and files her examination in chief as PW1 today. Present witness Dr. Chanda Mandal is examined and cross-examined and discharged. My evidence is over
Yeah.
on that day. It is fixed for further evidence.
Hmm.
Meanwhile, this application under Order 6, Rule 17 was filed. Now, my lord, kindly come to page 41. Only the operative portion. This is absolutely a character assassination, my lord. This should not be allowed.
Hmm.
Kindly see para 1. I don't want to read. Your lordship says read it, I can read.
No, not required.
In support of this, my lord, no document, nothing. How you
Hmm.
can level allegation against me?
What document would you file in support of your
My lord,
contention?
not only that,
File, but I'm having oral evidence which I can.
oral evidence.
You have always free to give depose oral evidence.
DW2, you can always bring the witness.
File my evidence.
This is your amended year. Where is your original WS?
Original W is there, my lord. Page 27. Only one paragraph I will point out, my lord. Page 27, the operative portion. Kindly come to page 37.
30?
37, page 20. 4 lines. Page, para 24 lines. Though name is not there, but it was within the knowledge of the petitioner.
Yes.
So this can't be
already you
allowed.
have stated.
Yes.
Because no name was not in that sense.
And you level character assassination by filing an application under Order 6, Rule 17.
This is not a forum for character assassination. You may get your divorce. That's all.
If you don't want to live with me, I am ready to give divorce.
separated.
The thing is that only the client, because this case has been filed only on the basis of mental.
My lord, the another point is also there.
Yes.
My lord, another point is also there.
Those point is required to be proved before the court. Mere raising allegation is not sufficient. No?
Mere rising allegation is amounting to cruelty.
No.
Yes.
She will be getting divorced.
My lord, one more paragraph I want to
True, my lord, just pass over. Mr. Tulsirali is on leg before the.
For the respondent number one state.
Just pass over, my lord.
Item six, Sarup gate, super bit for control.
After the petition, and for the response, my representative is rendering before the authority. That has to be disclosure within.
Just a minute, please. Item number 3.
The petitioner is the regarded tenant of class. And he has filed an application before the Tehsildar, for the Tehsil, for demarcation. Though the notice was given thereafter, on the particular date, the demarcation was not conducted, and thereafter, there is no notice, no further steps being taken. So, paying order within certain time is.
Yes, who is for the person? Yes,
Process has already been started. Maybe other adjacent plot holders were not present, for some of the other reason it could not be conducted. So already.
so I am giving direction to person. Take down. The petitioner applied for demarcation of land before the Tahsildar Port Blair on 26th of the April 2024. Being survey number 195 of 1A, measuring area 0.0051 hectares, situated at 51 hectares, situated at Jangali Ghat village, under Port Blair Tehsil, district of South Andaman. Due to inaction of Tahsildar, the instant writ application is preferred. Learned advocate for the respondent submits that due to submit that delay was caused due to engagement of Tahsildar in some other administrative work. But Tahsildar is not party, Andaman and Nicobar administration. Yes, respondents are directed to take necessary steps for demarcation of land of the petitioner within how much time?
8 weeks. As you take the months, take some time because I just got notice if they will not come again, they have to give us.
I am granting you 10 weeks. Within 10 weeks.
Within our
from 10 weeks
10 weeks.
from the date from the communication of from the date of the communication of this order, learned advocate for respondent is directed to communicate this order to the respondent authorities at once the petition is disposed of.
Well,
Yes.
Item 4, PR 48 of 2024.
Lordship, in this matter, learned counsel, Mr. Binu Kumar is on his leg there. So can it be passed
Pardon.
over?
Pass over.
Item 5, PO 48 of 2024. Service is that not completely. Transportation also like indicated that information is available. Why they serving on second term from the neither annual petition nor
On the prayer of learned advocate for the petitioner, let this matter appear on Monday on 10th,
Tenth.
Tuesday.
PR 49 of 2024.
Lordship, for item number 6 and 7, I am for the petitioner. Both are similar kind of matter.
Yes.
Respondent state.
On the last occasion, there was a direction to bring the CD, Lordship.
Yes, that is there.
May I start with the matter, Lordship?
Just a minute. Please give me a few minutes. Adjournment was where is the city?
Gurumani. नहीं, प्रिय दोनों एक साथ ही मेरी तरह।
In one case, Your Honor,
No.
these two.
What is in this matter?
Lordship for quashing of the.
Washing of the charge sheet, Lordship.
Yes. Yes.
Lordship, in this matter, there were some charges of medical negligence against these two doctors, petitioners.
Okay.
Now, Lordship, there was charges, and after that, the deceased father, he made initially a complaint before the Lieutenant Governor and stating that these people are involved in medical negligence. After which the Lieutenant Governor, he formed a committee, assistance from the Director Health Services. And this committee has gone into the allegations which has been imposed against these two doctors. And they have also given opportunity to appear before the committee. And after going through the entire matter, they have exonerated them from all the medical negligence charges. And after the final report of the first committee, they have given an advisory memo to these two doctors. Only one advisory memo. After that, the father of the victim, he was not satisfied with this. He came before the Honorable Chief Judicial Magistrate and filed a complaint case. Now, in the complaint case, the Honorable Chief Judicial Magistrate, he directed the SHO that to request the medical authorities to form a new committee, which will again go into the allegation of the matter, implying the principle which has been imposed in the Jacob Matthew case, and also applying the Bolam test. Now, Lordship, this committee again was constituted, the second committee, without giving opportunity to the doctors. They have given a report. Now that report, after and in the final report, in the final conclusion, they concluded that these two doctors are involved in medical negligence. And after that, Lordship, the police, after the second report, they have chalked the FIR against section 304A and section 34 of IPC against these two doctors. In between, Lordship, one of the petitioner herein, Dr. S. Gurumani, he challenged the finding of the second committee before a writ court. Now the writ court has completely gone into the matter, seen the order which has been passed by the Honorable Chief Judicial Magistrate, and they said that as per the order of the Chief Judicial Magistrate, it should be as per the Jacob Matthew case, principal lead, and applying the Bolam test, which was not applied by the second committee. On that basis, they have quashed the finding of the second committee.
Where's
Now,
the order?
Lordship, that I have enclosed in my petition, page number 76 to 87, Lordship. Page number 76.
Yes, Guru Mani has challenged.
Lordship.
Yes.
Lordship, the operative part starts from page 86, page number, paragraph 3.
Paragraph?
3, page 86.
Yeah. Which is second medical are hereby quashed. On the ground of non-compliance of Jacob Matthews.
Matthew
case.
K, Lordship. And also principle of natural justice was not followed.
Hmm.
And there was a direction to constitute a fresh committee if the health authorities want,
Yes.
which till now has not been. They have asked for the extension of time, which has been granted by the Honorable Court. Now, in the meantime, Lordship,
Yeah.
based on the finding of the second committee, this FIR has been chalked out. Primarily, when I have gone through the charge sheet, which has been given on the last date, it is primarily
Charge
based
sheet
on
filed.
yes, charge sheet file. We received the copy also. Now, the primarily it is based on the finding of the second committee, whose report is already quashed by the Honorable High Court, Lordship. So this is the situation now, Lordship. If trial will go, there will be no purpose in this, because ultimately it is totally
Trial?
based trial of the criminal case, which has been
Initiated on second FIR.
second FIR, Lordship. There is only one FIR only, Lordship,
No,
which has been
Yes.
made on the finding of the second committee.
second committee.
Second committee, Lordship.
So trial is going on.
No, Lordship, it is fixed for framing of charge.
Framing of charge. Then what is the order impute? Which order you have?
No, I have asked for the Lordship, the revision means the quashing of the charge sheet. There is no order because the lower criminal court has given the order only for framing of charge. They have not gone into this matter, the committee formation and all, because that will come only during the trial stage, Lordship.
Why you are praying for the questioning of charge sheet?
Because
What is
Lordship,
the ground?
the FIR on which the charge sheet has been supplied to me, it is totally based on the finding of the second committee.
That will be decided by the trial court at the time of trial.
Lordship, it is already
Questioning will not-
quashed. It is already quashed. Means the finding of the second committee is already quashed.
Quashed the report of medical committee.
Lordship. I will give the report,
Yes,
Lordship.
just a minute.
Yes, page number 24 to 75, Lordship. This is the final report, copy of the final report, and the finding of the second committee is page 75, Lordship.
Constitution of the second medical committee and its report dated 12th August 2022 are hereby quashed.
Lordship.
Report of second medical committee has been quashed.
And on that committee only the FIR has been chalked out.
So that's another thing. That's another thing.
That is,
Yes, sir.
Lordship, two things, Lordship. Charge sheet filed under section 304A and 34 IPC, Lordship.
Just
That
a
is
minute, please.
negligent act,
Please
Lordship.
give me a 1 minute. Yes,
That is negligent act, that is definition 304A, Lordship. Here regarding the second report of the committee constituted on the strength of the order of the Chief Judicial Magistrate Lordship that has quashed regarding connected with the departmental factor, Lordship. Second part is that here
No.
charge sheet already filed,
The
Lordship.
direction to constitute new committee was given there.
Lordship. Second report is there.
Where-
Not
where
only
is the
based
said
on that
report?
committee FIR has been lost. Lordship, thorough investigation was done. FIR, after registration of the FIR, thorough investigation was done. Lordship, that is regarding medical negligence. But as per IPC 304A, Lordship, regarding negligent act of any person, Lordship. Second part, Lordship, matter is fixed before the trial court for framing of charge, Lordship. Opportunity is still left with the hand of the accused person.
Yeah.
That is still left. If there is no prima facie evidence for framing of charge, for conducting the start the trial, has opportunity is there, Lordship.
Yes.
They can challenge it that no ingredients under section 304 IPC is
Where is the specific allegations?
Lordship, I am finding the charge sheet.
Yeah. No,
Page
char-
number 75, Lordship,
No,
of
no,
mine.
in city.
Okay.
City.
Lordship,
Tell me the finding of
just
investigating officer.
Yes.
Lordship, finding of the expert, Lordship.
No,
Lordship, charge sheet within the case done, Lordship.
what are the
Page number
evidences?
35, Lordship.
What evidences were collected by the IO to file charge sheet against them?
Lordship, that's finding on the basis of the second report.
Where
That
is the
what
second
was-
report? Where is
Second
the
report
second
is
report?
page
in your
number
study?
start from, which was caused by the start from page number.
Then after questioning, the report has no any importance.
Yes.
Lordship, that is regarding not for a criminal conduct of the accused person, Lordship. What was done during treatment of 15 years old boy and what was not done during that treatment, and in the result he expired.
Now, how can you say that this was not done and death of you, the 15-year boys was happened due to that negligence?
Lordship, that is purely a matter of trial, Lordship. We have to establish only prima facie evidence for framing the charge, for starting the trial only. At this stage, a strong prima facie not required, Lordship. This should dispute a
No.
question of fact.
Whether there was negligence on the part of the doctor.
Doctors, two doctors.
Otherwise, doctor will not treat any patient.
Lordship, Lordship, what happened? It means doctor will definitely treat us, Lordship. Some negligent or something was done by the doctors which was not ought to be done, and which was ought to be done, that was not some deficiency.
Where are those?
No, in the charge sheet also, charge sheet with the case diary, I am not with the.
Lordship, kindly
Charge sheet,
come to
Lordship.
my,
Case diary is with you too.
Lordship, I have handed over, Lordship.
kindly come
Sorry
to
for
page
that
35, Lordship, of my
Lordship.
petition.
Sorry for inconvenience.
Just a minute.
Page 35 of my petition, Lordship.
I will hear
Second
you.
paragraph. This is the, after the investigation of the IO. This is the finding, page 35, Lordship, paragraph 2.
Oh, this is final report.
Yes,
So charge sheet is there.
yes, I have
Then what
enclosed,
the city
yes,
was
I have
called for?
enclosed the charge sheet.
Why the CD was called for?
No, actually, last
You charge
occasion,
sheet is
I was
there.
not personally present, Lordship.
Yes, what you want to, so,
Lordship, page 35, paragraph 2, may I read, Lordship? Based on the finding of Dr. Sudha Patil, Professor and HOD, this is about the first committee. The Director NIMS and Director DHS have issued an advisory memo to the accused person of the instant case, namely Dr. Priya Krishna, Doctor on duty, and Dr. Gurumani, HOD of GB Path Hospital, advise them to take cautionary measures so that such untoward incidents should not arise in future. But the committee finding are unclear of whether there is any medical negligence on the part of Dr. Gurumani and Dr. Priya Krishna. This is about the first committee finding. Now the third paragraph is about the second committee. Further, the mother of late A. Nikhil filed a complaint case under this CRPC before the Honorable CGM Port Blair against the alleged doctor. The Honorable Court ordered to initiate an inquiry under this section on the basis of complaint of the deceased mother and offered to obtain an independent and competent opinion, preferably from a doctor of government service, qualified in that branch of medical practice, who can normally be expected to give an impartial and unbiased opinion applying Bolam test to the fact collected in the investigation. Later, as per the direction of the Honorable Court of CGM, Port Blair, and the requisition made by the inquiry officer, a fresh committee was constituted under the chairmanship of Dr. Shaji Varghese, surgical specialist, grade 1, GB Pant Hospital, and members, their name is there. Now, your Lordship, opinion of the committee based on fact after going. So, this is the finding of the second committee, Lordship. And the conclusion parties on the last page, Lordship, in which they concluded this, these doctors were found in medical negligence. Now, Lordship, medical negligence, what I want to put forth before the Lordship is, this is different from a normal negligence. We cannot say that these doctors are involved unless and until there is a finding from a specialist of same cadre. Because for in front of doctor, there will be 4 ways of doing the treatment, Lordship. And it is upon the doctor who decide which is appropriate in a given time, Lordship. So in this case also committees were constituted. The first committee has gone into the matter. They said that there is no medical negligence. And the second committee report is quashed. And after the second committee finding only FIR. Now if the trial will happen, Lordship, naturally the second committee finding will come.
No, FIR was lodged under which section?
304A and 34 of IPC.
Apart from medical negligence, criminal charges are also there.
Criminal, Lordship, that's what I'm submitting. In the case of doctor, medical profession, it is not a normal negligence which is required in a criminal case. It needs the inquiry and this thing of a reputed committee. Now, in this case, the committee finding is already quashed.
Yes.
Because Lordship is well aware.
How your IO arrived at the finding that medical negligence was the accused persons committed medical negligence, which caused the death of 15-year-old boy.
By adducing the witnesses who has furnished the second opinion, Lordship. Second opinion regarding medical negligence, Lordship.
That's why I want to see the statement of witnesses.
Lordship. Kindly come to the page number 36.
36 of?
36 of the that revision.
No, where 161 statement.
Is about 55 seconds. 161.
How many
55
witnesses were examined?
Page number 55, Lordship, of my application. 161 statement. Before that, Lordship, kindly come to the list of evidences, page number 28.
Last portion of page number 55, Lordship.
55.
55.
Yes. Yes.
Last portion. May I read, Lordship?
Yes, sir.
On 25 अगस्त 2022 को निखिल का हालत खराब होने लगा तो असिस्टेंट प्रोफेसर हरसिमरन ने निखिल को पेरेंट्स से हाई रिस्क कंसर्न लेने पर सर्जरी किया था, जिसमें बारे में केस शीट में डिटेल ऑपरेशन नोट्स मेंशन किया गया। डॉक्टर गुरुमणि है निखिल को कंसल्टेंट डॉक्टर के, जिन्होंने अगर यह सर्जरी पहले ही किया होता तो शायद निखिल बच सकता था।
Yes.
This one Dr. Ashwini Kumar. Then next page is page number 56. Statement of Dr. Shaji Varghese, surgical specialist, who has stated मेरे साथ कमेटी में और 4 लोग भी थे, डॉक्टर नारायण राजाराम, स्पेशलिस्ट ग्रेड 2 एनेस्थेटिस्ट, जीबीपंत हॉस्पिटल, देन डॉक्टर जूली सी अब्राहन, ENT kidney opposite such and such भी मेंबर थे। इंक्वायरी कमेटी ने डॉक्टर प्रिया कृष्णा और डॉक्टर गुरुमणि के एंड में नेग्लिजेंस पाया और उन दोनों को एडवाइजरी भी इशू किया है। मैं कमेटी द्वारा बनाए इंक्वायरी रिपोर्ट का पूर्ण समर्थन करता हूँ। बस मुझे इतना ही कहना है।
Which committee?
That is
This is the second committee.
Second committee.
second. Also, I am on negligent
Committee
act.
का समर्थन करता है.
Yes.
Yes.
Thus, all these expert or persons who have conducted that report, that was cost no doubt lordship, but I am not on negligent medical negligence. I am on criminal
Lordship,
negligence.
one
There
point.
is prima facie material against.
No, Lordship,
him.
no, Lordship. Kindly come to, just give me 2 minutes, Lordship. Kindly come to the same page, page number 55, in which the 161 statement is there.
Don't make submission.
Lordship, in
First you
this,
finish your submission, then let me allow to.
Lordship, since the other side has read this
Otherwise-
before this, Lordship, so I have to explain the points which are,
Yeah.
Lordship,
what
in
you-
page number
what you
55.
explain your point.
yes, page number 55, Lordship, from bottom, 10th line up, the same doctor, Dr. Ashwin Kumar. He said
Page number
page number 55,
55. Just a minute.
last 10 line, 10th line from the bottom, Lordship.
Just
He says, बोर्ड के पॉइंट ऑफ व्यू से कैजुअलिटी ड्यूटी डॉक्टर का इस केस में मेडिकल नेग्लिजेंस पूरी तरीका नहीं पाया गया. Now he himself says the medical doctor is Dr. Priya. So if
no, these are the factual. Yeah.
Lordship,
So,
one
that-
thing, Lordship, one thing, Lordship is right. One thing,
Let the fact be come before the.
I have to little explain about the background. In this case, what has happened, Lordship? The person, the boy has expired, and without doing post-mortem, they have taken the body of without knowing the cause of the death. So, Lordship, after every inquiry, also cause of death will not be clear because there is no post-mortem. Plus, the second report has been quashed only because the Jacob
The
Mackey was not
allegation
found.
against you that due to your negligence, death was caused. Post-mortem is not required in this case to exonerate you from from the charges.
So without knowing the cause of death, Lordship, because post-mortem will only ascertain the cause of.
Where is the post-mortem
Yes.
report? Yes.
No post-mortem has taken
No,
place in this
some-
matter.
After expiry of that boy, body was taken, I think, lordship, forcefully without examination. Lordship, all are
Okay.
disputed question of fact.
Yes.
Can be taken before the trial court.
Yeah.
And one step is late, lordship, in the hand of the accused person. File a petition under section.
It will be waste of time of court,
Time
Lordship.
of issue, we have. to
Because
establish
Lordship, the
that.
second committee only based on, but second committee finding only, and I leave.
Why are you confined to the report of committee? Investigating officer is also there.
Because it is based on Lordship on their report only, the investigation, they only say.
That may be in support of prosecution case or against the prosecution. That's another thing. And you may get benefit at the time of trial.
Lordship.
But that cannot be a ground for questioning of FIR. We are hearing petition for questioning of FIR.
Lordship,
So that would
Yes,
be the
yes,
whole.
yes.
Whether
It
prima
will be
facie material
waste of
is there.
time of the trial court, Lordship, because anyway they are finding it based on second committee finding report only, which is already quashed.
Okay, anything?
Negligent and negligent under section 304A IPC is totally different.
Okay, for order.
I'm grateful, Lordship.
In both cases,
Both
Yes,
cases,
Lordship.
Two accused persons.
Okay.
Same charge sheet.
Same charge sheet,
One charge sheet.
same submission.
Same.
Item 8, WBSC process for 2024.
My lord, I am appealing for the petition. My lord, I pray this matter may be taken up on Friday. One identical matter is already fixed on 6th of.
You are for the
I
petitioner.
am for the petition.
I put the state responded, Lordship, in connection of 138 of NIA.
Oh. 138 NIA, conviction.
No, my lord.
Oh, read. Question.
No, my lord. The petitioner, the read petitioner, the complainant filed an application praying for direction upon the police concerned to lodge an FIR against the accused under section 229A and 174A IPC. But the said application was rejected by the learned trial court, and thereafter the complainant
Okay.
taken.
On the prayer of learned advocate for the petitioner, let this matter appear on 6th. Parties are directed to complete. To come prepare.
Item 9, there are 30 of 2024.
I am for the responded state.
Well, I'm praying for password.
Also. Yes.
Item 10, CRR 52 of 2024.
Lordship. I for the state lordship. There are 4 accused persons, Lordship, before the trial.
Who is for the
Other side, Lordship, I have filed the affidavit of service. Lordship.
on the prayer of petitioner, where is the affidavit of service?
Service filed. They are actually resident of in Bihar. Pathanpur.
So,
The same matter may not arising out of number 2. Serial number 2. Both are the
Acha.
same matter.
de
De facto
facto
complaint.
I am for the victim.
De facto complaint, Lordship. Deceased, father of the deceased.
Father of the.
yes,
The
Sarma
state of-
case.
Separate 2 cases.
Separate.
Lordship.
Sarma case, Neeraj.
G.
Yes.
Serial number 2. Was that.
So, are you representing Amar Lak, ये Vinay Kumar?
No.
Vinay
They are
Kupra,
the-
I have filed, the state had filed.
Okay.
Challenge the discharge order, Lordship.
And you appear in which case?
Item number 2, by not
Serial number.
CR number 54. Arising of the same order against the
52.
same persons. He
Yes.
both are the criminal revisional application praying for setting aside the
And 54. Yes.
G.
54.
G.
So, but in absence of
Accused person.
Vinay Kumar, how could we proceed?
Service has to be affected from my side.
So no ex party order should be given. In that case, whether service item has been delivered,
Lordship delivered. I have annexed the tracking report, Lordship.
item delivered, yes.
Lordship.
So, it is better to appoint one advocate for SLAC or legal service authority
They are well off people, madam.
to represent
Because
accused in this case.
they are represented.
Actually, in trial court, there are 4 accused persons. One learned advocate Elango used to appear. One is facing the trial. Charge has been framed. 3 persons have been discharged.
But this matter. Childhood, I believe,
Child and, yeah.
My lord, in this matter, we may possibly have some instruction. But these people are all residing probably in Rajasthan. or
Pathankot,
Punjab.
Pathankot.
So the instructions and wakalatnama and all, probably it is not yet received. So that's why I think there is no instruction from the briefing council.
You take necessary
They can take
instruction.
the instructions.
When should I fix it? When should I fix it?
But give me a week's time. Let me just get the main thing I need is a wakalatnama before I address the court. Once I get the wakalatnama, then other things can be seen. And if my learned friends would just serve me a copy, then that would never need to take the instruction.
I can. Can I agree?
Take down.
In both the matters, my lord, may.
No, in item number 2, you are representing. So item number 2, I think.
No, my learned friend is for the de facto. I'm talking
Oh,
about the.
de facto,
offense.
yes.
Probably the de facto has challenged in one.
And
State has challenged in the other.
who is for Jagjit Kumar? Jagjit Kumar. And other side is the state. And others are not here.
No,
State and others.
that respondents, other
No, but
respondents
in
are.
any event, then my lord, that will not be maintained.
Hmm.
Because without hearing us, no order could be passed. Probably.
No, you are correct, but when none appear, then what remedy is here?
No, if
Some
my
sort of
friend
order
has
is required to be
challenged an
passed, no?
Order of discharge, then the accused persons who have been discharged, they have to be heard.
Discharge
Yeah.
from? No, discharge from?
Discharge from case, what has happened if I'm not.
Who discharged?
That
the
respondent
accused
three,
Persons have been
three
discharged.
numbers of respondents.
That is what they have challenged. There was a Navy officer posted here. He was married with a wife and a minor infant child, daughter. Now, this Navy officer had some sort of an argument with his wife. And in the background, he came back from his duties and he found that the wife is hanging from the ceiling and the child is dead on the floor. Over this, the police arrested him because the suspicion was that he has killed the wife and child. As per what I remember of the matter, there was some investigation, forensics, and it was found that the wife, in a fit of anger, had strangled and killed the child. And when she realized what she had done, she became completely hysterical and hung herself.
These are concoction.
Now,
These
no,
are
I'm
concoctions.
making my submissions
These are
on what are my instructions.
No,
Now, whatever
no,
is
we are
this,
not here.
Heavy
Just-
concoction.
whatever is
Just
this.
he is
we-
briefing me about the.
Yes. Now, whatever is this, an FIR is ultimately started. 302 against the wife for killing the child. But that case abates because she herself committed suicide. And 306 so far as the wife's suicide is concerned, with 498, 834 probably.
304.
Now there, the husband was the principal accused. I'm not for the husband. Now, the entire family, uncles, aunts, cousin, niece, nephew,
Mother,
father, everyone.
498.
4%.
498,
4%.
because they are residing at Rajasthan, Haryana,
Hmm.
Punjab, wherever. They have never even come to Andaman Islands. They are not even residing here. They have no contact with the wife. They have nothing. But they were all dragged in. So when that FIR happened and they were subsequently added there as accused, they moved an application for discharge. And after considering the materials on the points of Bhajanlal, the learned court below was pleased to find that there is no prima facie case or material against the family members.
Hmm.
But the court said that other issues are matters of fact relating to the husband. So husband discharge is refused and husband is to face the trial. But so far as all the other extended family is concerned, they were discharged.
Hmm.
Now against that, my learned friend, Mr. Tulsiram, has
That
come up
order, yes,
for the de facto.
order of discharge.
That is
Challenge.
item number 2, where Mr. Lal has challenged, as a de facto, he has challenged the discharge. So there, I would be appearing for the discharged accused persons.
Hmm.
Mr. Lal has generously said he will serve me a copy. Now, The second matter has come thereafter, where probably Mr. Karmakar was appearing in this matter, item
Yes.
number 2. Now thereafter, the state has taken out an application on the same issue, where they are also now challenging the discharge of those extended family members. Probably this is the background. Now what is to be done is those 4 or 5 persons who are resident outside, I don't know whether they have been served or not, they are to appear, for which we first of all need a vakalatnama. Without a vakalatnama, I am hesitant to address the court.
Yes, you are correct.
So my lord, that's why I was saying to get the hard copy of the vakalatnama will take some time unless your lordship bends the rule little bit and allows me to show a soft copy. But that is not.
On the
strictly-
prayer of learned advocate for the state, let this matter adjourn for a week. I am not recording your copy.
I'm good.
Lordship, affidavits of service I already filed. There you go.
Affidavit of service submitted by learned advocate for the state is taken on the line.
My lord, I will
Let
come.
this matter appear before the is taken on the record. When should I fix it? Before
Next Wednesday is 11th, my lord, that will be 11th.
would you get
They can-
Vakalatnama by then?
My friend is saying it is doubtful. Speed post from Rajasthan may take 10 days or so. Let it otherwise be placed in the next circuit, because then I will have the written instruction. I would be confident to.
Let this matter appear before the next circuit.
My lord.
Thank you.
Great.
Both the matters, my lord.
And my
Yeah,
lord,
both
let them
fine.
be tagged, because they rise
Both
out of the self same order. They can be tagged.
Item number, item number 2 and item number,
Govinda, go to action in tag.
item number 10
2 and 10.
are arising out of the same self incident. Let the hearing of the matter. Item number 2, item number 10 are arising out of the same incident. Both records shall tag together for the sake of convenience.
Great.
License.
My lord will not take me amiss without the Vakalatnama we have addressed
Yes,
the
sir.
court.
It's not fair.
This is only to assist your lordship.
Yeah.
Great.
Chal, next.
I am appearing on behalf of the respondents. They have to file their reply.
My senior Ms. Nag appears on behalf of the petitioner, your lordship. We have received the opposition 2 days ago. I pray for time for filing the reply.
You are for the
Petitioner.
petition. So what reply?
I have filed the opposition as per the direction of this honorable court and handed over to the,
What opposition? What is in this matter?
it is pertaining to grant of electricity connection.
Then what opposition is there?
Lordship, there are certain difficulties. So I have, in my opposition, I have explained each and everything. The petitioner is not in settled possession. Earlier,
No, whether petitioner is residing there or not.
no. That is.
Where is the
difficult.
report in that? So when should I fix it?
It is as per their choice, Lordship. They have to use
Yes.
their reply.
Madam, when should I fix it?
After 1 week, your lordship.
Why? Why 1 week? I am fixing it on Tuesday. 10th. On the prayer of time to file affidavit in reply. Learned advocate for the petitioner grace for time to file affidavit in reply to the affidavit in opposition filed by learned advocate for respondent on 13th November 2020. Let this matter appear on 10th December 2024. Learned advocate for the petitioner is directed to file the same positively on the adjournment.
Okay.
Your Lordship, I have filed the affidavit on 13th November, but I have not served the copy. Just now I have served the copy.
Your Lordship, whether it is a need for filing reply and AO.
No, if he-
I am only
if he-
asking
if-
Not
for the
required, not required.
electricity.
Why
As my client
opposition?
is residing in the house.
Two things are there,
Your Lordship,
whether you are residing there or not.
Your Lordship, I am residing.
If you are residing, so whether you are enjoying electricity connection or not.
Your,
Are you enjoying
Your Lordship. No, not earlier. Is it a new for the new connection?
for the nickel?
New.
Lordship,
Then-
kindly come to paragraph number 7, page number 4 of the writ petition. They have relied upon a circular issued by the government of India
No,
and
Whatever
the
be
date
the,
of birth of the writ petitioner.
whatever be the circular, but you cannot
He
deny
is claiming the benefit of that circular. Lordship.
paragraph number,
Then he has not major at all. How he will encroach? the
paragraph
land?
number 4.
7, page number 4, paragraph 7 of the writ petition.
Your Lordship, my client
The
is residing in the
petitioner
house.
states that the joint secretary, UT Ministry Home Affairs, intimated this Chief Secretary that ministry accorded sanction to provide electric connection to the families residing in the revenue land.
Government revenue land.
On the revenue land, yes. Where is the circular?
I have enclosed along with my opposition. Lordship.
So as to facilitate.
First
meeting
portion of the circular. Lordship.
So the electric connection to the.
Cut-off date is given March 1993 and the writ petitioner born on 1987.
So what is the relationship with the board and the circulation? I am
You have
asking,
relied upon the circular,
No.
your paragraph is there.
only I am asking the connection.
In the age of
that
6 years,
connection.
he has encroached the landed property.
No. Since when you are residing there? You are residing this way,
Yes. Yes, village
yes,
with my family members.
since long,
Since long. That's why I am asking.
She has born in 87, Lordship, as per
yes.
her affidavit.
87.
Page
now
number 10.
to 24. That means.
We
40
are
years,
not in
40
24.
years. 40
The
years.
circular cut-off date
My
is
client
there.
is 40 years old.
Not forget about the circular. If there is electric supply in that village, so why you are denying? What is the ground for denial? Not to
Lordship, many encroachers, they have encroached the
Encroachers.
government revenue land.
encroachers, yes.
Encroachers, they have encroached the government revenue land. And we are the legitimate customer. We are not getting the power due to we are providing them. As per their paragraph 7 pleading, Lordship, they are relying upon a circular. When she was 6 years of
If
age, she has encroached the
they
government
are,
revenue
if they
land.
are encroacher, then what step administration has
It is
taken?
the
against-
revenue department who has to take the task. It is
They are,
not
they
the,
are residing on encroached land. Since long.
as per their.
Department
Since
has
long.
given the thousands and
She has
thousands
gone
connection
in
and
1987.
he denying to me. Why
She
not
was
all?
born in 1987.
Why pick and
she-
choose? Why
and-
pick and choose?
And she is claiming the benefit of 2003 scheme. That scheme
Sir,
provides the
providing-
cut-off date.
Providing water, electricity.
I am not against lordship,
Is
but
the
he has relied the
fundamental right.
paragraph
You
number
cannot
7.
deny.
Because paragraph number 7, he has relied in the writ petition. In that notification, cutoff date is there. Whoever encroached prior to March 1993, they should be provided the electric connection and water tap connection in the government revenue land. That is the difficulty.
You have to apply only JERC, not circulation. What is the JERC? He is the Department of Electricity. Electricity Department has to apply the JERC.
If he is not filing
As
any
per
reply, I
JERC.
will let him argue. I will argue the case.
What is the argue? I am asking for my client that connection.
Yes,
It is
I
a
am
mercy of the state and of the court.
But your paragraph number
in
7
any
is disturbed.
in any event, he is entitled to get connection. In any event, he is entitled.
My submission may be recorded, lordship, necessary order may be filed.
Take down. Where is your prayer for electricity connection?
You receive, my application is page number 11.
The petitioner
28.
made an application to the assistant engineer, Chaudhary Subdivision, Electricity Department, South Andaman, on 28 October 2023 for availing new service connection for supply of energy. New service connection to
Ranjita Mandal house.
where is your address?
Your Honor, your Lordship, page 12.
To
Near
survey
Lush
number,
village
survey
Haspatal.
number, oblique plot number 100 oblique P, near lush green retreat of village Hasmatabad under Perarganj Tehsil, South Andaman, where he is residing since long without any electric connection. Since then, his prayer is pending. His application is pending before the authority due to non-action on behalf of the authority. He preferred this writ petition for necessary direction to the authority in this respect, in this regard. Learned advocate for the respondent authority filed affidavit in opposition on behalf of respondent number 1 and 2. He submits that petitioner prays a- for connection on the strength of a circular of Ministry of Home, Government of India, dated 9th May 2003. But the necessary requirement of the said circular has not been complied with. So he is not entitled to get any connection. He is not entitled to get any connection or any relief under the said circular. Anything more on your behalf? Circular, that's all.
Circular, that's all.
So he prays for dismissal of the instant rate as is not maintainable. Disputedly, the enjoyment of water, electricity, etc. are the basic requirement for a dignified life of a citizen. This is the constitutional obligation of the authority to provide electricity connection to his citizen. And denial may amount to violation of Article 14, 16, and 20. It is also ये एक और के सच some केस के रेफरेंस दिए देवे अमर मनी अभिमन्यु the full bench of Honorable High Court has decided in Abhimanyu Majumdar versus Union of India. That even encroachers are entitled to enjoy electricity. Considering the facts in the light of the ratio decided in the above cited case, I am of the view that petitioner is entitled to get electricity connection. Respondent authority is directed to provide the connection within how much time you?
4 weeks.
I am granting you 6 weeks
Not true.
to avoid any embarrassment. Within 6 weeks from the date of the communication of this order, landed advocate for the respondents are directed to communicate this order immediately to the respondent number 1 and 2. Accordingly, this petition is disposed of.
Highly opposed.
I am appearing for the respondent.
My lord,
Uh,
from item 13.
Are you for electricity department?
Lordship.
My lord, for item 13 to 18, Mr. Prakash Minj is appearing for the writ petitioner. I pray these matters may be fixed on Monday, my lord.
Why Monday, sir?
He proceeded to North and Middle Andaman. Lord. I got it.
Okay. On the prayer of learned advocate for the petitioner, let this matter appear in list 30 to 80.
13 to 18, my lord.
On Monday, parties are directed to remain present on that day. Do you need some direction to file anything required?
Lordship, here 13, 14 and 15 I have received the copy. 16, 17, 18 I don't have any copy.
You serve copy to
My lord.
here written. Item number 16, 17, 18 যখন লিখবেন 18 ওর যখন লিখবেন ওই সময় দিয়ে দেবেন কি where is the record? Deputy Service Record কি বলছে 16, 17, 18. বলবেন কি learned advocate for the petitioner is directed to serve a copy of this of writ petition to learned advocate for the respondents in the meantime. You serve copy if you have copy, serve him immediately. 17, 18. हाँ तीनों में ही बाबा बाकी 13, 14, 15 तो হবে learned advocate for both sides is present. And this matter is adjourned on the prayer of Sure.
For 19 and 20, I will use my opposition. Lord.
Well, here, the rejection has been given. I have applied for and
I will use
rejection,
my opposition. Lord.
rejection has been given
Ah.
on the ground that kindly be seen.
Did you file your opposition?
No, Lordship, this is first day appearing in the list.
Okay.
On the ground that.
Let him file his.
Not that, this was filed 2 months back. Madam. We filed on 4th of.
But no
October
direction was given to him to file any affidavit of service on return. Where is your affidavit of service?
It was filed on 4th of October 2024, sorry. Well, it was served on, though I have not filed.
But no affidavit of service
Well,
is.
it is there, my lord. I have not
So
filed.
you
it.
file na? First you
Other
do
side
your
is
work.
appearing, my lord. Now
First you
other-
do your work.
Other side is appearing in this matter.
Serve copy of writ petition to your
All
counter.
it is-
No, I am having one copy. Lordship. She has served me in advance.
Okay. Learned advocate for both sides is present. Learned advocate for the respondent pays for time to submit affidavit in opposition. When should I fix it?
2 weeks time will be granted. Lordship.
2 weeks is too much.
Lordship, because it has to route through law department, everything, and it has to be vetted and come back.
Now file it by 12.
It is not possible, Lordship, because it has to be routed. I am appearing on behalf of the authority, Lordship, not a private individual.
Yes. Do you think that opposition is necessary?
Lordship,
What opposition will you give? Whether they are not residing there?
I have to take instruction, Lordship, field inspection has to be done, whether they are in settled possession or not.
Before giving
No.
me the electricity, this can be done, my lord. This
Let
can
me
be done.
use my opportunity, Lordship, to file opposition.
Let me fix it on 13th,
13th, it is not possible, Lordship, because
16th,
I have to prepare it, I have to send to the department.
16th.
Let it be in the next circuit bench, Lordship.
Okay. Let this matter appear before the next.
Like,
I am appearing for.
My
the
lord, let it be
official-
on Monday, the service not affected to the private respondent here.
Respondent is here.
I am appearing on
Mr. J.
official
Shashi
respondent.
And who is the private?
Demand number, so respond number 4. I'll file my.
Who is the respondent number 4?
It is a
J.
private
Shashi-
respondent.
Private respondent, Mr. J. Shashi Kumar.
Why he is the respondent? Junior engineer.
There is a sale agreement between the private respondent and so that is the reason. Without my consent, the meter connection was given in the name of the,
Where is the affidavit of service?
I'll file tomorrow, let it be on Monday.
On the prayer of learned advocate for the petitioner. Let this matter appear on Monday. He is directed to file affidavit of service on the adjourned date.
My lord, from item number 21 to 24, Mr. Prakash Minj is appearing, my lord.
Generally, I used to appear for the department. I have no copy of the writ petition. Whether they have served or not, I don't know.
Serve the copy of writ petition.
My lord.
Learned advocate for the petitioner. Praise for an adjournment. He is directed to serve copy of the writ petition to the learned advocate for the respondent. Let this matter appear on Monday. 9.
My lord.
Item 25, double case of 2024.
Yeah.
And for the Forgery Municipal Council. Here, my lord, say, learned counsel Tapan Kumar Das is appearing for the petitioner. Today he is unable to appear, so not today, my lord, due to some personal.
What is in this petition?
Copies may be served, but I think it related to water.
Who is for the petition?
The learned counsel Tapan Kumar Das, my lord. Today there is a
And you?
personal difficulty. I am just representing you on behalf of him making submission.
In what capacity you are representing?
Proxy council, my lords.
That's not good.
Not today, my lords.
Let me record his absence.
Let it be not today, my lords. Tomorrow he will be available.
But how can I entertain your submission?
Rest I am leaving.
Learned advocate for petitioner is present. Should I?
No, he is not.
Then
Rest I am leaving.
none appears on behalf of the petitioner. Nor any accommodation is paid. Petitioner, nor any accommodation is paid for. Let this matter. When should I fix it?
Tomorrow, my lords, he will be available.
So do not today, sir. Not today.
26 also, my lords.
Item 26.
Same order, my lords. 26 also. Not today.
Why all? You all are so casual. Are you not interested in disposal of matters?
Some personal difficulty, that's why he requested me, my lords. Nothing else.
What personal difficulty? Were you not aware that this matter will appear in list today?
He was there, my lords. He came before this court.
Then
there
what
are-
difficulties is there? Anyhow,
Yes, my lords.
it is
Problem,
not
lords.
my concern.
Problem, lords.
Yes,
Item 27, CRA SB3 of 2022.
7, I am here for the discharge accused.
discharge accused.
Acquitted accused, sorry, not discharged. The acquitted accused.
I am for the state lordship response.
Yeah, record the. Yes, you are arrested. Since last 3 days, I was waiting for you.
Lordship, Monday or Tuesday, lordship.
I heard.
Your Lordship, my senior Miss Nag appears on behalf of the petitioner, Your Lordship.
Yes.
I pray for a short pass over, Your Lordship.
No, let us start. Nag is for
The petitioner, Your Lordship.
petitioner.
This is an appeal against acquittal. She is the appellant. not-
Who is the appellant?
Defective complainant, victim.
So her presence is necessary.
Lordship.
তুমি কখন করতে চাও?
Huh?
তুমি কখন করতে চাও?
আমি?
So call her, we'll take up this matter. Letter. We'll take up this matter. later.
I'm ready.
You are ready and
Samokar, I
you
think
are available as well. I know.
I am always there.
Yes. So we'll start hearing after short break.
Madam, very well, please.
Yes. After short break, we will.
Published.
Next. 3 matters are passed over in the name of her senior.
No, I am here, man. I'm not.
No, no, you are for acquitted person.
28, SAT1 of 2023 with child to SAT2 of 2023.
Yes.
My lord, my senior Mr. Gopala Binukumar is appearing for the petitioner. I pray for short passover may be given.
The when should I hear? Okay. Call the list.
30 PRA every 4 of 2023.
Who is in 30?
I'm for the appellant.
Are you ready? Both of you are ready?
Can it be on Friday, my lord? Because this morning I traveled back from Calcutta. I went for the exam of my son. He appeared in the class.
Oh. You are?
I'm for the appellant.
For the, against conviction.
Yes, yes. So you just start. Will you adjourn it after hearing some salient point and
My lord.
item number 30?
30, my lord. 30.
Yeah. You are appellant.
I'm appellant, my lord. I have been convicted under section 7 and 8 of POCSO Act.
Against conviction.
Against conviction, I came before this honorable.
argument.
You should-
Other matter will be.
Let it be tomorrow. I'll do it tomorrow positively.
Same will happen tomorrow.
No, it will start soon, your lordship, because other matters, I will be attending tomorrow this court, taking adjournment there. So I will be doing it tomorrow. It will be done, your lordship, positively.
Yes, Mr. Kabir.
It doesn't matter is there, my lord, once she finishes, only then I will open my mouth. Then I won't open my mouth.
Tomorrow I will do it.
We can do it tomorrow, depending on Mr. Karmakar also, because he has to also prepare himself. So. State also what he wants to do. And he's also overburdened.
Then our this is item number 30. अरे तो अनेक अच्छा करते तो अनेक अच्छा I सब WP की है what is in that WP कम से कम 37 तक करेंगे Okay, you come prepare tomorrow. And the learned PP is always ready.
He's on the toes, my lord.
If submit some written notes of argument, if
I'll conclude my argument and then.
part heard. Yeah, item number ये दीजिए. Item number. Item of 27. नहीं यहाँ पर भी था 27 है ना और 28 item number 4 में क्या है 4 तो डाकी item number 2 is also okay. Yes, item number 4.
Matter, item number 4, there are 48 of 2024.
Yes. What is in this matter? Who is for the other side?
For the state lords.
Oh, estate. Yes.
Whether today or tomorrow, my lord.
As you wish.
For the convenience of.
My desire is to continue. At best, I can give a rest for 1 hour. And thereafter we can start. Are you comfortable or not?
I can do as per the convenience of the court, I can do.
So my convenience is not in question.
Then let it be.
Your convenience may be.
Oh, my lord, let it be day after tomorrow, because tomorrow Miss Nats, that matters are there. Day after tomorrow, my lord, I will do it. Because tomorrow my certain matters are fixed. Today also I have done some hearing matters there.
We have very few days in our hands.
Yes, madam.
And anyhow, what is in this matter?
In this matter, my lord, we have challenged the order of the Learned CGM, whereby the final report submitted by the police was accepted.
Yes.
We filed a Naraji petition against that. That was rejected by the police and accepted the final report submitted by the police.
Yes. Then
That is under challenge.
yes, learned people. Can you throw some light?
Lordship, civil in nature offense, 420, I think 468 regarding forgery in respect of sale deed. Then civil suit pending between the parties. FIR registered, but final enclosure report have been filed by the police.
Now, if there is a allegation of forgery, then it should be decided
Lordship, I have.
by
Then complainant,
Narajgi petition has not been entertained,
Lordship,
and why FR final report was submitted.
first time, then second time also.
Why?
Do one, na? You know,
Due to want of some evidence.
Lordship, from the face of the charge sheet, the learned, because the IO has filed the charge sheet, Lordship. Investigation officer filed the charge sheet, Lordship. Not charge sheet, that is final report, that no case is made out. But
Yeah.
civil in nature, saying that civil in nature. So, learned trial court has accepted that. In response, the complainant filed an Narajgi petition. But one order have been passed, that final report have been accepted by the trial court.
A specific performance.
Yes, 2 suits are pending. I got from the charge sheet. Huh?
Then
No, my lord.
is it related to a
Offense was
specific?
constituted. Offense was constituted. My lord, may I place the case? Sir?
Yes,
My lord, may kindly come to page 19.
19. Yes. Today.
My lord, an ex parte decree was passed. My lord, may kindly come to page 22. Operative portion, my lord, last paragraph. Plaintiff do get a decree with the direction upon the defendant to execute the sale deed in respect of the suit property in favor of the plaintiff, after complying all the formalities. Here what happened, my lord? This plaintiff has filed this suit for specific performance against my husband on the basis of a alleged sale agreement, when my husband was missing and thereafter never found, my lord. So whatever may be, on the basis of an agreement, purported agreement, he filed a suit and obtained a decree. Now, my lord, here, if my lord sees in the order, the suit properties, my lord, may kindly see page 19, suit properties, survey number 1971 by 1. Kindly have a note of this, my lord. Now, my lord, after this, my lord,
Survey number 1971.
1971 of 20 of 1, my lord.
Yeah.
This is the suit property. Now, my lord, may kindly see, after this, my lord, he filed an execution case before the trial court.
Yes.
Now, my lord, may kindly see page 23. Now, my lord, since as per the case of the plaintiff, the defendant did not come forward, he filed an execution, and in execution, he submitted a sale deed before the executing court. Now, my lord, kindly come to page 23, order dated 29th April 2014.
29th April 20.
This is in execution case. My lord, dates are very relevant.
Yes.
Now, case record is put up. Learned advocate files a petition stating that as per the order of this court, the plaintiff has submitted the final deed and the same has been sent to the sub-registrar for registration purpose. Learned advocate submit that it has come to the notice that there is a typographical mistake in respect of survey number. It is stated that correct survey number is 1979. Now, my lord, this number changed. 1979 by 1.
What was the?
1971 earlier.
Oh,
Now he says,
1971.
he says,
No, 1971.
earlier it was 1971 in the decree.
Yes.
And when he filed execution, when he
Different
submitted,
number. Yes.
yes, when he submitted before the sub-registrar refused to register the sale deed on the premises that this land doesn't belong to the defendant. Now he taken out an application before the trial court saying that it was a typographical error
survey number is wrongly written in the suit.
Yes.
Therefore, he sought for correction. Kindly see page 24.
Yes.
Page 24. There is a typographical mistake in respect of survey number. It is stated that correct survey number is 1979 by 1, but due to mistake, it has been mentioned at 1971 by 1. It is submitted, plaintiff be permitted to put the correct survey number, which is so and so. Now, my lord, I had the learned advocate. I find from the schedule that the survey number has been mentioned is 1971 by 1. The plaintiff has not filed any petition for correction of the survey number as mentioned in the schedule. I think that the survey mentioned in the schedule of the property is required to be corrected first. Considering the above, that application was rejected, my lord. Now, my lord, this application was rejected. Dates are very relevant. On 29th April 2014, it was rejected. Got it, my lord?
Yes, application for execution.
No.
No. This is a put up
This is for correction, my lord.
correction.
Correction. Wait, this is 29th April 2014.
Yes.
Now, my lord, what he done, my lord, after this was rejected, he taken out one more application, page 25.
Page
Page 25.
25.
This is dated 17th of June 2014. My lord, may kindly record the date, my lord.
Yes, sir.
It says that today, by put up application on the basis, today is the plaintiff has filed 3 applications. First application filed by the plaintiff under Order 6, Rule 17, second under 152, and third under 151. Now, learned advocate first moved the petition under Order 6, Rule 17. It is submitted that the learned advocate that the suit was decreed on 28th of June 2013, granting decree for specific performance of contract, and acting upon this said decree, one sale deed was sent to the sub-registrar for registration. Thereafter, it has come to the notice that the survey number mentioned in the sale deed wrongly written as 1971 by 1 instead of 1979 by 1. Learned advocate has further submitted that due to typographical mistake, the said survey number 1971 by 1 was written in the schedule of the claim. It is submitted that the learned advocate, the schedule of the property in the plaint is required to be amended as per the schedule of amendment of the present application. I heard the learned advocate. I have carefully perused the entire record as well as the agreement of sale of immovable property executed between the plaintiff and the defendant. Considered on perusal of the agreement for sale of the immovable property executed between the parties, I find that in the schedule of the property of the said agreement, survey number has been mentioned 1971 by 1, situated at Aberdeen Bazaar. On the basis of the said agreement for sale, the present suit was filed. In view of the above, that it was not a typographical mistake for which survey number so and so was shown in the schedule of the plaintiff. Considering the above fact and circumstance, I am not inclined to allow the application, hence the application was rejected. Now, my lord, kindly see this application was rejected on 17th of June 2014. Now, my lord will find, I will show from the sale deed first, and thereafter I will show the orders of the court. My lord may kindly come to this sale deed, page 30.
Yes.
Now, my lord, page number 31. This is the sale deed, my lord. In terms of the decree, the court has page 31. My lord, see the date at the top, 22nd July 2014. Now, my lord, 26th July 2014, sale deed was executed. Now, my lord, court has rejected it on 17th of June 2014. 22nd July, sale deed was executed. My lord, may kindly come to page 32.
32 and
Sale deed. Now, my lord, may kindly come to second paragraph. Page 32.
yes.
Whereas the vendor Mohammed is absolute owner of the land bearing 1979 by 1. It was corrected. Handwritten, it was corrected. Admittedly, the application was rejected on 17th of June. On 22nd of July, sale deed was executed in pertaining to survey number 1979 by 1. Now, my lord, I could have appreciated, my lord, that thereafter there is no order of the court. Now, 22nd July, the sale deed was executed in survey number pertaining to survey number 1979 by 1, when admittedly in the court record the survey number is 1971 by 1. Now, my lord, may kindly see in order to secure the wrong and the offense which has been constituted, so that tomorrow no problem should be initiated and that nobody will see that it was done. My lord, he filed one more application before the court, page 27, on 21st of August 2014. Now, by this, he again seek for amendment before the executing court. Now, kindly see, today is fixed for passing order. The plaintiff has filed the present petition for amendment in the plaint as well as so and so instead of survey number so and so. At the time of hearing the learned from content, the defendant number so and so on the basis of so and so. The power of attorney survey number correctly written, but due to some typographical. My lord, entire case is there. Now, my lord, may kindly come to last page 28, last paragraph. Because he then placed the power of attorney before the court. Now the court says on perusal of the power of attorney, it is found that survey number being written as 1979 by 1, it is fact that on the basis of the said power of attorney, enter the sale deed on so and so sale agreement. It is on the basis of the sale agreement plaint was prepared. It appears to me that it was a bona fide mistake on the part of the so and so permitted to amend the plaint as well as so and so. Hence, I am inclined to allow the application. The application under so and so was allowed. Now, my lord, this application was allowed on 21st of August 2014. Sale deed was already executed on 22nd of July. This is absolutely an offense. This is what I am embarking from. On that day onwards, my client is from pillar to post, my client is running. This is the exact case, my lord. Now, my lord, can you see how investigation was done? I am placing the two reports of the investigating authorities. Now, my lord, can you come to page 45? It starts from this. The first investigating report was of 21st of July 2019. It starts from page 39. Relevant is page 45. My lord, may kindly come to page 45. My lord, may kindly come to first paragraph.
Yes.
My lord, may kindly come to 11th line from the top.
Yes.
It says plaintiff again.
Yes.
On 1st August 2014, filed the petition before the Honorable Court, and the Honorable Court, after considering all facts, circumstance, passed an order on 21st August 2014 and on perusal of the so and so. Meanwhile, next paragraph, my lord, may kindly see. Meanwhile, the sub-registrar has registered the sale deed on 22nd July 2014 and subsequently the survey number was corrected. Now, my lord, may kindly see. It is not that the investigating officer was not aware that on 22nd of August 2014, his application for amendment was allowed. Amendment was not carried. Court has allowed his application, you file an amended plaint. Now, my lord, he says in the meanwhile, sub-registrar registered it. Now, my lord, this is an offense. How sub-registrar can register it on 22nd of July 2014? So, now, my lord, kindly see the last part of the said page 45. My lord, may kindly come to 9th line from the bottom, my lord.
Yes.
It says, my lord, PK Mohammed on so and so, but the survey number was written wrongly. Survey number 1979 by 1 was wrongly written as 1971 by 1 and passed on the sale agreement, proceeded before the civil judge so and so, only when. And my lord, can you see, which was realized only when the sale deed from the court was sent to the sub-registrar. Got it, my lord? Thereafter, accordingly, the sub-registrar followed due procedure, registered the sale deed on 27. My lord, here the investigating officer went wrong, my lord. On 27, how the sub-registrar can register? Because it was never corrected. Therefore, the survey number mentioned is so and so bears correction, so and so.
Once rejected on that ground.
Once rejected on that ground, how it can be done without, and my lord, kindly visualize the situation. Firstly, what he has done, my lord, he manipulated the sale deed there. Manipulated the sale deed there. But he for the purpose of caution, he thought it better that though the sale deed is registered, but in near future, no issues should be raised. Therefore, I will file an application for amendment. Once he filed it, my lord, there an offence was constituted. It clearly reflects. Now, my lord, this is the first investigating officer report. Now, my lord, the second investigating officer on the same line, My lord, may kindly come to the second investigating officer's report. It starts from page 47 and the relevant page would be page 53. 52, my lord. Same findings, my lord, as if copy paste, my lord. Page 52. Ninth line from the bottom, my lord. Page 52. Again on 1st August 2014. Filed a petition before the court, and the Honorable Court, after considering all facts, passed an order dated 21st of August 2014 that on the perusal of the power of attorney, it is found that the survey number has been written as 1970. It is fact that on the basis of the said power of attorney, enter into the sale deed so and so. True is that on the basis of the same plaintiff was prepared, it appears that it was a bona fide mistake on the part of the plaintiff, and plaintiff is permitted to amend the proposed amendment for rectification of his mistake. This was the order of the court. Meanwhile, page 53, my lord. Meanwhile, the sub-register Port Blair registered the sale deed on so and so, and subsequently the survey number was corrected on survey number. My lord, here offence is constituted. Now, my lord, the investigating officer has taken in such a low manner, my lord. Now, my lord, may kindly see that paragraph. Ninth line from the bottom, my lord. Same paragraph from the bottom, ninth line, my lord. Accordingly, the sub-register.
Yes.
Accordingly, the sub-register followed due procedure of law, registered the sale deed on so and so. Further necessary correction on surveys are also allowed by the court, and therefore the survey number mentioned in the sale deed to Nazir by the court bears correction in so and so in 9 How, my lord, my entire case is that when it was not amended by the court, you registered a sale deed and handwritten, my lord, that is 1979. That was handwritten. Now 22nd July 2014, sale deed registered. Thereafter, he filed an application on 1st of August before the trial court. Trial court allowed the said application on 21st of August to file an amended application. Then also amended process was not completed. So, my lord, offence is constituted. The police officer in a low manner that anyhow in the midst it was done. This is my case, my lord. Kindly appreciate. I am a lady aged about 60 odd years. I am running from pillar to post from last several years, my lord.
Yes. You have some case. Would you reply today or tomorrow?
No, any date, lordship.
Tomorrow. Ready
Lordship.
at the top of the list.
Lordship.
Yes. Any more matter?
My lord, item number 28. There I have filed paper book.
48.
No, that. I said it 20. 28, my lord. There, my lord, I have.
Second.
If my lord sees the report, the file was not reached. Thereafter, the court has passed an order. File came. They have given me letter. I will inspect and file paper book. So direction may be issued. 8 weeks time may be given, my lord.
Tomorrow, not today.
My lord, if I am not there, my junior will make appropriate submission.
Okay. अब तो क्यों नहीं? ना रख में.
Lordship, item 34 and 35, I'm appearing in VC. I pardon your lordship.
You have to wait. 28, 29 होएगी क्या? 30? Or the list till 37. 37.
Item 31, stand 8 of 2023.
He's out of station, let him be on Monday.
You are further?
It's a Jaypal appeals for the appeal.
Not today.
So then Monday, he'll be available on Monday.
Attend
The
on.
direction by this honorable court for paper books. And we are already paid the amount for the register. Is the order is there.
On the you are for the petitioner? Opinion. Petitioner can look at that. Paper book ready? Learned advocate for appellant prays for an adjournment to file paper book. Where should I fix it? Let this matter appear on Monday. Yes. Item number 32.
Yeah, for the respondent.
None appears on behalf of the petitioner. Are you for the petitioner? Not today, कोई नहीं ये करता. Not today. Yes, 33.
33, CR 26 of 2023. I for the state lords.
Not today.
Item 34, CO 40 of 2023.
Lordship, I am appearing on VC, Lordship. Pardon, not Lordship.
Yes, yes.
Lordship, actually, I am appearing from Odisha, so I have to appear from VC because yesterday only I traveled from Port Blair. The matter didn't reach. Lordship, this matter is pending from the last 1 year and 3 months. The petitioners are not even pursuing the matter.
I am appearing for the state, but my lord, it's principally a private dispute. From what I understand, the petitioner and the respondent have some contractual.
Yes. The state has the decree holder has already withdrawn the awarded money in the last year only. This matter was remanded back from the Honorable Supreme Court on the solely on one basis for the validity of a deed of agreement and a check. So the
No, what is your prayer?
Petitioner is not here.
Petitioner is for
Yes,
respondent, private respondent, and petitioner's advocate
Petitioner.
has
Yes,
requested
yes.
me to pray for not today because he is unwell. my
Only for not today.
no, Lordship. I am appearing for the decree holder, the respondent number 2.
The
State has no role to the government has no role to play because it's a private.
play, but the advocate for the petitioner, Mr. Das, has requested Mr. Dwivedi to take not today because he's not well and has left the court premises. So if my lord keeps it for tomorrow, my lord, then maybe.
Okay, not today.
Lordship, so then again, this matter will be taken up tomorrow.
Appeal tomorrow.
Obliged.
35.
35 is connected, same, my lord.
Item 36, CR 8 of 2024.
So inform kar do.
Yes. Not today.
Let it be on Monday.
Not today. Not today. No.
Tomorrow, he will not be available.
You are for the?
Sir, Binu Kumar is for
My
the.
senior is appearing for the petitioner.
On the joint prayer of both sides is appear. You are for the
My senior is appearing for the petitioner.
petition and you?
The respondents.
On the joint prayer of the parties, let this matter appear on Monday. 37.
Item 37, CR 40 of.
I appear for the petitioner, Mr. Khattar. This is a very strange situation. An accused person is actually a senior police officer. This petitioner is, or rather was, inspector of police. He conducted a raid in an NDPS case after getting the source information. Now, when he has gone to the particular spot, the person who owns the house has run away from there. And a lady was there. The lady claims that the person who owns the house is her spiritual father or Baba. Now, I conduct the raid. I recover a huge amount of narcotics. And I leave the place. Now, later on, the lady files a complaint saying that I have tried to outrage her modesty. Now, This matter is so strange because your lordship just needs to see three pieces of paper. Now, in this matter, FIR is lodged, that is at page 17. Now, after the investigation, it is found that there is no material whatsoever against me to save her so-called Baba from the criminal prosecution in NDPS case. This lady has made a false case. Kindly come to page 83.
But FIR shows that prosecution was initiated under section 354,
354 modesty.
506.
And the star witness is the accused in the NDPS case. He says he ran away from the house because of the NDPS raid, but he was hiding outside in some bushes. Can you see page 83 first?
83.
Page 83 is an opinion written by the learned public prosecutor.
No.
After the investigation was completed, no material was found. So the matter was placed before the learned public prosecutor. Learned public prosecutor came to the opinion that the entire case is completely fake and motivated case. That is at page 83.
No.
Can you see annexure P7? Page 83.
83 at 83 annexure P8. P7 is at 82.
I'm sorry, then the page is not matching.
82.
82 then.
Yes.
82.
Yeah.
Kindly see.
Yes.
Now, what learned public prosecutor writes, kindly see. Alleged incident of outraging of modesty of the complainant was occurred early in the morning at Atho on so and so when the complainant was sleeping in the rented house, did not lock the door of her room. She wake up on hearing the sound of opening the door and found the accused person. Accused person first inquired about Uttam Kumar Dhali, that is the accused of the NDPS case. And in reply, the complainant said she is unaware of the whereabouts of Uttam Kumar Dhali. Then the accused caught her hand and thereafter started to touch on private parts of the complainant. Though IO has examined as many as 19 witnesses, version of the complainant was not corroborated by any witness except one witness, Dipankar Vishar. The complainant was also examined by the learned magistrate, recorded her statement under 164. She narrated the same incident which has been narrated in her complaint. One witness, Dipankar Vishar, was also corroborated the allegation of complainant. The time which has been mentioned in the complaint for commission of offence of outraging of modesty of the complainant is important factor. In that time, nobody is likely to be available in the locality of the rented house of the complainant. It is astonishing to see how Dipankar Vishal has collaborated the version of complainant. The complainant is residing in the rented house of Uttam Kumar Dhali. Uttam Kumar Dhali was arrested by the police accused on the same day for commission of offence under section 20A1 of NDPS Act. Sri Uttam Kumar Dhali is so-called Baba of the complainant. It cannot be out of place to mention here that the complainant is making a false allegation against the accused Sub-Inspector K. Ilangovan, that is the petitioner, to save her so-called Baba from narcotics case. Moreover, another aspect has to be seen that she has made a complaint to the Director General of Police in which she has mentioned that the date of her molestation by K. Ilangovan was on 26th April. In the first paragraph, third line, kindly see it is 23rd. She is mentioning different date of molestation by K. Ilangovan. Considering the above position in mind, I am of the opinion that the allegation leveled by complainant is nothing but a fabricated, motivated and false complaint against K. Ilangovan. Now, public prosecutor endorses this to the SHO, PSCCS. It is going all the way up to the SPCID. Kindly see the last line. Discussed, final report be prepared. Thereafter, kindly see page 3 pages after that. FRT is filed. Now, my lord has got it. The final report, number 2 of 2019.
Final report, yes.
So, case against me is closed. FRT is given.
Yes.
Even PP has given the opinion and the matter is closed. Now, very strange thing happens. I have a issue with the Director General of Police. I am an inspector. Now, Director General of Police has made certain comments about me. Over this issue,
I had made a complaint against the DG. My lord will kindly come to page 114.
Yes. Costly implication.
Page 113, annexure P11.
Hmm.
My lord will find I had made, kindly see the date. The dates are very important. This is on 25th of July, 2021. I have made a complaint to the Lieutenant Governor against the Director General of Police, although I am his subordinate officer. Now, various things have been happening for a long time. Those are described in detail in this complaint. On the next page, again, there is a further complaint I have made. So this has all happened in the month of July.
Yes.
Now what happens? The reason for this is that the Director General of Police, who was then at that time posted, he was making some comments on Twitter. So far as I am concerned, so far as other persons are concerned, some personal comments. Now it so happened that one of those matters resulted in a writ petition which came up before this honorable court. Kindly comes to page 170.
How much time will take?
The matter will take some time.
So let me fix it tomorrow. Computer.
My lord, at the top
Now
of
I
the
am
list.
feeling hungry.
My lord, everyone else has gone for lunch. Now I am the only one standing with Mr. Kormukar. My lord, let it be at the top of the list tomorrow, my lord.
Okay.
Part third, top of the list.
Part top. Both of you may file a written notes of argument if possible. Or salient point. That may do.
But we are not reassembling today. We will come back on.
If you are ready, then I am always ready.
Tomorrow, top of the list. I live 25 kilometers from here, my lord. If I have to go for lunch, then coming back is very difficult.
Your residence is 25 kilometers from here.
Out of the town.
Okay, then you are not required to come. Go and take rest.